Well, thank you all for being here. My name is Barath Chari. I'm a partner with the Technology Transactions Group at Wilson Sonsini. So we're a Silicon Valley-based law firm. We've been working with technology companies for 70 years now here in the Valley. In the AI space in particular, we represent more than half of the top 50 AI companies, including OpenAI, Anthropic, Google, Stability, and others. I'm one of the co-leaders of the firm's AI practice, and what I do is commercial law, so helping with commercial relationships, commercial transactions, as well as the interplay between commercial strategy and intellectual property. Um, I have 20 minutes here, and just based on what everybody's already been saying, there's a lot of interest in kind of legal and law and AI and what it is. So I'm just going to do a very, very high level overview of a couple of topics, but I'll be here in case people want to talk about other stuff. And if you want to interrupt me and ask questions, please feel free. So a couple of the things we're going to talk about here. The first is some considerations that companies should think about when they build generative AI products. That's whether you're going to try to build a model yourself or whether you're trying to build a product on top of another model. A second set of topics is around IP and IP ownership and AI and the intersection there. The third are a couple slides on some of the key legal risks around AI, and the fourth are some regulations on the horizon. So I think we've already heard some about the fact that to build a generative AI model, you need a lot of data. And where does that data come from? What rights do you have in that data? So there are a few areas where our clients tend to seek data because there's large volumes of high quality data. The first is through a university data set. You can go on a lot of academic institutions and find really large sets of very interesting data, whether it's experimental data or survey data or observational data, all kinds of data. The thing to keep note of when you access that data is although it's free to access, it often has non-commercial use limitations on it or other restrictions on it. So it is important when you actually obtain that data to think about what rights you have for use and to ensure that you're trying to use it in a compliant way. It may seem small, but when you're trying to raise a Series A and your investor asks you, hey, do you have all the rights to all the data you used to train your model? And the answer is no, that's going to complicate your fundraise a lot. Um, a second thing is open source. So people think open source means free. I can do anything I want with it, but that's not true. So open source is a license that has restrictions tied to it. There's open source software, there's open source data. Again, free to use, but you have to make sure you understand what the restrictions are on that use and make sure it comports with what your use case is. The final thing here is on web scraping. So all the foundation models out there now at their core were based on scraping the entire internet. And as you've seen, all those foundation model providers have been sued. So scraping the internet is a high risk endeavor, and that's an important thing to keep track of. So a couple of the risks in particular to be aware of. The first is copyright infringement, and we'll come back to this more, but I'm sure you've all seen OpenAI was sued by the New York Times, Meta was sued by Sarah Silverman, Stability was sued by Getty Images, Anthropic was sued. Everybody's been sued. And why have they been sued? Because in scraping the internet, copyright owners claim that their copyrighted information was copied and used to train the models. So the defense to those copyright claims would be fair use, which we'll come to in a second. But just quickly want to note that copyright isn't the only set of risks around scraping off the web. Um, there's plain breach of contract claims. So there's a terms of service on a site, and if that terms of service says you can't scrape this site to make an AI model, and then you scrape the site to make an AI model, the person who runs that site can sue you, right? That's infringement of the terms, right? So depending on how those terms are accepted, et cetera, you could have stepped into a breach of contract claim. There's also weird old-fashioned sounding claims like trespass to chattels, which is like a very old common law action about like if you touch a man's horse and it gets hurt. On the internet, what that means is if I put a whole bunch of strain on your server and my server isn't able to respond to people as fast as it should, I could claim that you've trespassed to my chattel, you've trespassed to my server, and there's a tort claim you could bring. So there are all kinds of ways that you could get in trouble for scraping. So it's important if you're going to think about using scraping as the foundation to get data to try to think about those risks and engage in that scraping in a compliant way. Now, about fair use, right? So, this is the billion-dollar question about the industry is is what OpenAI and Anthropic and Stability and Google and Meta is what all they've done, is it fair use? The thing about fair use that's complicated is a it's not a license. It's not a right to train. It's a defense to an infringement claim, which means if you're sued for infringement, you show up in court and say, "I'm actually okay here because my use was fair." Which means in order to win on fair use, you have to go through a really long trial and prove a bunch of facts and win. So for those of you who know anything about law and fair use, Oracle and Google fought in the courts for more than 10 years on fair use. It went to the Supreme Court multiple times. And even at the end of that, the result is murky. So nobody knows what's going to happen here. And it's not a stable foundation on which to build an industry, but it's what we have right now. So the things you think about in fair use are the purpose and character of the use, right? What is the use I'm taking? The nature of the copyrighted works. Is it a piece of art? Or is it just some information from a newspaper article? How much of that work was used, and does my use have any effect on the market for the work which I used? And all those factors get mixed up into a blender with other stuff, and a judge goes and makes a choice. So it's not really clear how these things will turn out, but it's kind of the core of all these cases. So it's going to be interesting to see how that continues to play out. Now, I think many more companies that we see these days are not trying to build their own models, but are trying to work on top of models, right? They use a foundation model, an LLM, and LAM, a product which does RAG on top of an LLM, all kinds of things in order to build their own, right? A couple of things to be aware of. The first is there's a similar dynamic happening now between open and closed models as has happened in the past between iPhone and Android, or Linux and Windows, where there's kind of two ecosystems being built between open and closed. And companies are kind of picking sides between one or the other and trying to see what it is that they want to do. The interesting thing now is there's an antitrust law angle to this, which is just starting to appear, which is called open early, closed late, right? So what open early, closed late it's an antitrust concept that comes up with the fact that oftentimes companies start with an open model, they become entrenched, and once they're entrenched, they switch to close when the market's already kind of locked into what they did, which was open. And that's a competition concern then, right? Because you've kind of exposed the whole market to being reliant on you because you're open and then you shut things down. So it's going to be interesting to see how this plays out over time, especially with these open source models as their capability increases substantially. But I, I, I think the thing I would note is that there's a lot of interest in using closed models currently because they're easy to use, they're sophisticated, they perform quite well, um, and costs have been coming down. And there's still a bit of a learning curve for companies to come and ingest these open models and to build something on top of them. But even that bar is coming down over time, so it'll be interesting to see how that plays out in the coming year or two. The thing I will say though is in all circumstances, when you're building on top of another model, it's really important to understand the terms of that model. I know there was a question earlier about who owns the data that's input, who owns the outputs. All that stuff is a matter of contract, and that contract is the contract you accept with the provider or you negotiate with them. So it's really important to ensure that as you're trying to get into relationships with a vendor or a partner to build AI tools, to to look at those terms from both a strategic perspective to understand what's important, but also from a pragmatic perspective. Because the thing you have to understand is that OpenAI has way more customers that are trying to talk to them than they can negotiate contracts with. So if you're going to be the squeaky wheel that tries to fight over stuff that isn't important to you or them, you're not going to get a contract done. So it's really important to understand kind of what the context is of the landscape what parts of terms are important and try to push for the things that matter. Now let's do a quick talk about IP. I think that people think they know what IP is, but there's often a misunderstanding. It's not one thing, it's a few things. So there's two core parts of IP. One is in intellectual property rights, which are intangible things. So that's a trademark, which is a right to protect a brand name like Swiss Necks, right? There's a patent, which is a right to have the exclusive right to make, use, sell a novel invention or process. So that's a physical thing, or software is implemented with a physical thing. Um, and that's a monopoly on use for a fixed period of time. Tends to be 20 years here from the application, so long as you tell the world how this thing is made. There's copyrights, which I think we know are rights to works of authorship, which is things like a book, software code, a movie, a song. Taskworks rights are a subset of that in semiconductors. And then there's trade secret rights, like, for example, the recipe of Coca Cola. And that's something that's very valuable because you keep it secret. So those are the four types of IP rights. But what IP rights tend to attach to are actually items of technology. So software, a Xerox machine, a piece of paper, a computer, right? And the thing that's important to keep track of as you're thinking about these things is things like patents and trademarks are a purely a legal right, something that says I have the exclusive right to do this. But things like copyrights or trade secret rights are actually tied to something, right? So a copyright is tied to a piece of software, it's tied to a book. It's not just a thing in abstract of its own. Having a copyright license to something means absolutely nothing unless you actually have the thing itself that you're trying to exercise that on. Unlike a patent, where if I have a patent right on something, I can see how it's done, I can exercise it. So this is important now when you think about what the outputs of AI are and who owns what, right? So the first thing when you think about the ownership of the outputs of AI, you could get software code of it out of AI. You could get recipes for how to make a really cool soda out of AI. You could get inventions on what a pharmaceutical pathway might be. But two things to keep in mind: AI generated output is not subject to copyright. It's not copyrightable. Because in order to be copyrightable, something has to be made by a human. So there was a famous case where a photographer set up a camera in the jungle and a monkey took a selfie, and he tried to register for copyright at the monkey, and the court said no, because a monkey's not a human, and a human has to actually be the author of the work. So um, AI assisted inventions are not categorically unpatentable, but just the output of AI in and of itself is unpatentable. Because again, a patent has to be invented by a human. So if you're an inventor that's going to use AI as part of your processes, it's important to understand what your role is in that work and how you can file for something that gets protection, right? So if you're going to rely on AI tools to build up an IP portfolio, it's really important to look strategically at your use and try to understand kind of what you're trying to do and when, so that you can get the maximum protection. The final thing I'd note is trade secret rights are a valuable thing, and a lot of entrepreneurs don't really appreciate that. I think, for example, I work with hundreds of startup software companies. Almost none of them have a patent. Almost none of them have ever filed for a copyright. But what they do is they keep their source code secret. So, from a practical perspective, if you're going to use AI to generate software code, if your terms make clear, as most terms these days do, that the outputs belong to you and are only for your use, and you keep those outputs secret, you only share them under NDAs, then you still have a valuable proprietary right in that source code. It's just, again, important to keep it secret. Um, Copyright infringement. So we talked about the fair use and copyright infringement, but here's a key risk area to keep track of when you're looking at AI outputs. So the first thing to note is a copyright owner has 6 exclusive rights that only they have a right to do. They have a right to reproduce the work for example, to make records or CDs, make images, make proofs. They have the exclusive right to prepare derivative works of that work. So that's to translate a play from English to Italian. That's to take your work and put it in a new setting. They have an exclusive right to distribute copies to people. Um, if it's a performance art, you have the exclusive right to public performance. So, for example, I can't buy a DVD of a movie and show it outside. I can't make a public performance of that movie. I can only watch it internally in my own house. Um, and then for sound recordings to perform it publicly. So again, I can't take my record, which I bought, and go and play it in Central Park for a crowd. I have to hear it at home. So if you're the author of a copyrighted work, you have the rights to sue people for infringement if they engage in any of those things. So what you can imagine here is if you're the owner of a copyrighted work, let's say an image, and an AI model provider, say Stability AI, were to go out there and scrape the web and make copies of my copyrighted works in order to train my model, they they claim that their exclusive right to make copies of their works was infringed because again they made copies of the work. So which is why fair use is an issue, and again why copyright infringement is a big hot topic here as far as AI, right? um, the thing that's important to also remember about copyrights, and this is for entrepreneurs out there that are trying to develop works, is that AI uh, is that copyrights protect expressions and not ideas. So you can't copyright an idea. But it can copyright that expression, the idea, as written up in an article, as written in software, etc. Um, so we talked a bit about this already about AI and copyright infringement, but there's there's you know it's going to be a hot topic here as far as what the liability is for these foundation model providers. The thing that's interesting and tough for them from a factual perspective is if you ask often these models to do something in the style of a famous work, you'll get something that looks a lot like that work, and it's hard for them to then it's hard for the providers often to explain how that work could have come about if they hadn't made copies of the original copyrighted work in the first place, which is again where the fair use arguments will be important. Breach of contract claims I touched on before, but a big one here is against GitHub and Microsoft, who built GitHub Copilot by using all the software on GitHub, a lot of which was open sourced. And when you get outputs from Copilot, it doesn't give attributions to the open source authors, which is a violation of the open source terms. So there's a breach of contract claim among other claims in there. Um, Two more quick things. The first is kind of as far as where the laws are going here in the U.S. The Biden administration put out an executive order around AI, right? Because they view AI as a really emerging inflection point in history that brings all these concerns with it about national security, consumer harms, privacy, etc. The thing to just keep note here is this executive order still has to be implemented. It's just kind of a statement of what the current executive thinks. So there's a ton of work to be there. A whole bunch of rules still have to be passed. So there still isn't anything yet on the federal level. States are acting on their own, but even those are more privacy focused right now. And finally, in the EU, the EU AI Act passed. It passed on May 21st. So it still needs to be implemented. But what it does is it has a risk based framework on AI models, which are categorized based on risk, which is unacceptable, high, medium, and none, essentially. And if you don't adhere to its obligations, there's severe penalties here. It could be 7% of your annual turnover or 35 million euro, whichever's higher. And I'm not an EU expert. If you want to talk more about what it does, I can. But just safe to say that the obligations there are going to start to kick in around the end of the year and then phase out from there. So that was a lot of talking about a lot of stuff in a very short period of time. I don't even know if I have time to answer questions. I can take one maybe, but if not, I'll be here afterwards. So if you want to chat, I'm here to chat. So oh, one, here we go. Yeah. So yeah, so one of the things that the Biden executive order does is it asks the Department of Commerce to start to do studies on the copyrightability of AI outputs and the patentability of AI outputs. I think there's a recognition now that the law will have to change in the same way that I can get copyright in a photograph, even though that's me hitting a shutter on a machine because I'm setting settings. What does that mean in AI? So I do think there will be kind of some kind of changes in the law over time, but it's not clear what those are. And there's also the fact that things like copyright are also governed by international treaties and international conventions. So there's going to have to be some level of international consensus. And in some countries like France, they're going to be far, far less amenable to AI ownership of art than in other countries like China. So trying to get these